All right. Hello, everybody. Welcome to Immigration Options for Laid Off Workers. We appreciate you joining us today. It's a very pertinent topic with all the layoffs going on here in Silicon Valley and beyond. If you are a worker who's here on a visa or looking to figure out how to help somebody who may be here on a visa, this is the session for you. And today we've brought in Ashima Dugal. She is an immigration attorney who can answer these very questions. This event is recorded. We're going to have a lot of, we're going to have a version of this up on YouTube on when it's complete. And you can also visit and rewatch the video on our Facebook group. As far as questions and answers go, I think Ashima is going to go ahead and answer these questions as she goes, as the webinar goes, or in her own choice. And you're also more than welcome to ask either in the webinar chat or in the Q&A. Well, without further ado, I'm going to go ahead and give it over to Ashima, and she can go ahead and get herself started. Thank you for coming back for us and doing an encore.
Hi, everyone. I hope everyone is doing well, despite your situation and your recent termination. I am sorry to hear of the termination. There have been maybe almost 200,000 since early this year and late last year. I do understand a little of what you're going through because my husband was also terminated on January 20th from Google. He was once an H-1B visa holder, and now he does have a green card thanks to me because he married me. But he's still in shock a little. It's been more than a month. But I also understand that he is in a better situation than you, because he does have that green card. He doesn't have the stress and the added anxiety and fears, that he has to find a job in a particular time frame. So this screen, if you have questions that are not answered, or you wanted to discuss in detail green card options or O1 visa eligibility, etc. I have reduced my hourly fee. It's normally $250, and now it's $125. You still get a lot of information in 35 minutes because this presentation is very comprehensive, and you're going to learn a lot. And then when you contact me, if you contact me or if you contact any attorney, you already know your options and you know what questions to ask. So it's very, comprehensive, full assessment. All right. Okay, so I've been practicing since 2004. I have my own practice in Silicon Valley, and I love that. It's more gratifying. I have more contact with the actual clients, whether it's the companies or you, the individuals. And I do believe that the interests should be aligned. In immigration law, there's dual representation. If I'm representing a company, I represent the company's interests, but I also represent your interests. And they should never be in conflict. There are occasions where they are, obviously. And so if I'm doing a perm case for one of my clients, I do it as fast as possible. And I always encourage HRs and managers to please consider that the H-1B visa is expiring, in 18 months, and we need to do this quickly. And that's what I mean by I represent the employee's interests as well. I know there are a lot of questions, and so I have been helping my clients and other new clients on this exact issue for several months now. I know you have a lot of questions, so what you could do is ask questions through the Q&A chat based on the topic. And this is going to be, this first screen is actually, I know, might generate some questions, but let's go back here. So my goal for you is that you, sorry, I'm just moving this box. Okay, you make a short-term immigration plan. Maybe some of you were just recently terminated. Maybe some of you have been, already in your grace period. You need to make a short-term immigration plan. What are your options? And then start pursuing them now. You can also start thinking about a long-term immigration plan. Maybe your perm was underway, or maybe your I-140 hasn't been filed yet or was filed and pending. So you can self-sponsor. You need to figure out how much time do I have left to get a new company sponsor, a new job, those sorts of things. So in general, these are your options, and this is the agenda, basically. So let's just get right to it. So again, first, we're going to talk about grace periods. I hope all of you have been advised by your companies or your immigration counsels of those companies that what is your grace period, like the actual dates. I know there's a lot of differing legal analysis here, but basically in the state of California, companies should be giving you a notice period and then a grace period. The grace period begins on the last day of your employment, and that could be the last day of your notice period, okay? Generally, if you look at the second bullet, your date of termination is your last full paycheck date, okay? I'm gonna just open this, and see what questions are people asking. So people are asking a lot of questions about H-1B transfers. And let's see. So are there any questions about this topic? What is your grace period? How do you calculate it? Obviously, you just, look at your paycheck date. You should be receiving a last paycheck, and it doesn't matter if it says 0 hours. It should not say severance. It should say, again, maybe it says salary, maybe it says supplemental income, whatever it says, it kind of doesn't matter. USCIS seems to be not too worried about that legal term of, how to classify that paycheck during a notice period. If you weren't given a notice period, you weren't given a notice period, unfortunately. Maybe you can talk to an employment lawyer. Why were you not given one? And, you can decide if you want to talk to your HR about that. And I recommend you do. Okay, so somebody is asking, so thank you. What if the company does not provide the notice and directly lays off? Does WARN Act come into the picture? Maybe, in California, there's a notice period. I'm not an employment lawyer. I'm an immigration lawyer. I specialize in employment-based immigration and family and naturalization. So I think that you might, want to talk to an employment lawyer if you feel strongly, and of course, it's very important. You get additional time. You get additional pay, of course. A lot of smaller companies don't know, simply. Maybe some smaller companies may not be required under the WARN Act. Maybe it's only, for larger companies. So, I can refer you to somebody local that I know. She's very good, small firm. Her name is Stacy North. And I will put her, in the information in the chat. So somebody else is asking, my last date was January 13th. H-1B grace period expires March 13th. Okay. Can I apply for tourist visa by March 8th, 10th? Yes. So we're going to have a slide about that. But let's go back. So Nishant, have I talked to Nishant before? I think I have, in a presentation, not one-on-one. So Nishant is asking, laid off January 20th and my health insurance coverage ends today. I'm sorry. Okay, I'm New Jersey. I don't know about health insurance. You're asking a health insurance question. But generally, I think you are eligible for Obamacare. That is not considered like a public charge issue. You have been told that if a non-immigrant uses government subsidized health insurance, it affects their green card application approval, leading to rejection. No. I think Medicare, Medicaid might, but but I think Obamacare would be fine. I'm pretty sure, Can we transfer the H-1B to multiple employers at the same time and decide which one later to join? Maybe. That's not the topic, but we are going to talk about that. There's a slide on this. So should we move on past grace periods? Generally, if you look at this slide and this topic right here, that by day 30 of your grace period, not your notice period, your grace period, I think you should have a plan and start taking actions. I'm just, okay. And we are going to talk about what kinds of actions you can take, when you should take them. But, you know, I start acting now in your notice period. I get this question a lot from my clients and others. Travel during grace period, I wouldn't recommend it at all. Because when you return and you show your visa stamp, you cannot, you know, earnestly and legally say that you are employed. You're in a grace period, you have been terminated. Okay. So I know there were a lot of H-1B port questions, so here it is. Obviously, port means transfer, H-1B transfer. Okay. I'm just gonna go ahead and read this slide. I'm just gonna look at the chat. Okay, so somebody, okay, great. So it's no questions for me. Got it. H-1B transfer. Obviously, this is the, you know, your number one goal if you are on an H-1B visa. The LCA labor condition application is a pre-step. It is a critical step. Without the LCA being certified, USCIS may deny and likely will deny the H-1B transfer case. The LCA is taking 7 to 10 days because Department of Labor is inefficient, basically. I don't know why it takes 10 days. But that means that for your own peace of mind, and this is so important, that you need to start planning on by day 40. What are you going to do? You need to urge your company saying, okay, well, I know you think we have 30 days left on my grace period, but you haven't started the LCA. You need to start it. You need to start it. And then within that same time frame that the LCA is pending, a lawyer, a law firm should be doing the rest of the case. So by day 50, you file it. There's no reason to wait until the LCA is certified and then file, and then do the rest of the case for the H-1B petition, get signatures, you know, do a degree evaluation if needed. All of that takes time. So in my practice, that's what I do. While it's pending, we do it. And then sometimes we do the whole case in a couple of days, and the LCA comes back, we get it signed and we submit. Day 55, you know, we're having bad weather. There are storms, there are floods. You know, you don't want to wait until day 58, day 59 with FedEx. You may not get there. So again, everybody already knows that they have discretion. And before I even look at the Q&A, I know there are some questions popping up. I want to just explain what is concurrent notification. What are the two parts to an H-1B petition? By the way, we are going to talk about L's and O's and TNs, but right now, I do believe 98% of the people on this call do have an H-1B. That's my guess. So, you know, let's say your grace period ends, you know, April 1st. And the case is submitted, you know, filed or submitted on April 2nd. And so it's receipted after the grace period. And by the way, they're going to look at that paycheck, okay? USCIS to calculate those 60 days. There are two parts of an H-1B petition. One is the H-1B eligibility. They're going to look at the company. Is it a legitimate job offer? Is it a specialty occupation, a prevailing wage, et cetera, et cetera. All of that, you know, should likely be approved. You know, if you need to do that analysis, certainly, you know, speak to an attorney. The other part of it is the extension of status. And on every H-1B petition, there is that question, what are you seeking on the I-129 form? Are you seeking an extension of status, a change of status, an amendment? What is the action you are requesting? And so in all cases, even after the 60 days, so, if you get a job offer from a big company, and a large tech company, and they have their own immigration counsel, by all means, you need to ensure they select extension of status. They might in their minds think, well, it's been 90 days since the paycheck. They're never going to, approve it, USCIS. You never know. USCIS has discretion. They need to be requesting the extension of status, even beyond the 60 days. So USCIS may or may not approve that extension of status. So when you get that I-797 notice of approval, on there, it will say the H-1B petition has been approved. The extension of status is denied. That's basically what it will say. And what that means is that you have to get back into H-1B status. They feel that because it's been more than 60 days, you haven't maintained your H-1B status. That's the legal term. If you have a valid H-1B visa stamp in your passport, the visa stamp, not the I-94, the visa stamp, then you might be able to depart the country, and you could go to Jamaica or Mexico, go on a little vacation, couple of days, and then re-enter and present your H-1B petition approval to the officer and your visa. And they should issue you a new I-94. So the worst case scenario isn't that bad. Are there some risks? Yes, but I think minimal. Again, this is an option if the extension is denied, the extension of status, and you have a valid visa stamp. Let me see what questions are there about this. Okay. Anonymous, what if company lays you off when you are out of the country? Are you in a notice period or a grace period? So Anonymous is asking, what if company lays you off when you are out of the country? If you're in your grace period, then you cannot legally re-enter the country and present your visa because you're not coming for employment purposes at that point. If you're in your notice period, by all means, come back as fast as you can. Okay, I'm going to scroll down. Oops. I'm just looking at another question. My last day was January 13th. Okay, this is the tourist visa question. So I think this is the only question regarding H-1B transfers. How can that be? Okay, I think that's okay. Somebody is asking about multiple employers. I had this exact consultation today. Can I transfer my H-1B to multiple employers and later decide which employer to join? And then the second part to this question is, can the company ask for H-1B fee if I do not join them after my visa is approved with them? I mean, there is no, let me tell you about the second part. I mean, employers are required by Department of Labor to pay the filing fees and the legal fees. So, you know, they cannot legitimately ask you. I mean, they might get upset that you didn't join. And especially if they paid for premium processing, which is $2,500. They can try, but there's no legal contract, right? There's no contract that requires you to reimburse them. Now, as far as the first question, can I transfer my H-1B to multiple employers and later decide which employer to join? So I do think that that's, maybe it makes sense, you know, you're just trying to land whatever you can in the grace period. I do think that you do need to find a job within the grace period. I think you could decide at the time, you know, maybe if it's day 30, day 45, by all means, accept that job offer and get them to file it so you remain in the grace period. But if you're doing like 3 at the same time in the same week, I don't know if that makes sense to me. Like, what is the logic? There is a rule called last action day, final action. And that means that the H-1B that was approved with later validity dates is what controls. So it can get very confusing and tricky as to, you know, where you have that employment authorization. If you have multiple ones, you could also, you know, be in that situation where you have to withdraw the other ones and then just have one and notify USCIS essentially through, you know, through the last, through the company, you know, lawyer where you want to work. I'd be happy to, you know, if you refer me to any smaller companies, even mid-size, they will be fine working with an attorney, even if they have their own, because a lot of companies do have multiple attorneys. And so because I know your situation, that can be helpful. So I think I answered everything regarding transfers. Dibu Singh is asking, I have 3 offers right now. Good. But with the current economy, I'm not sure what if one of them starts laying off or rescinds the offer. I think that you should have that conversation with the recruiter or the manager. You know, I think certain industries, you know, maybe are safer. You know, it seems like more layoffs are in software tech companies in the Bay Area. You know, maybe you want to switch to manufacturing. And so Debu says, even Amazon said it's safe, but they laid me off. Well, I mean, I talked with somebody recently, you know, who is, I guess, with AWS, and they did mention that AWS told their employees that layoffs are not over. Sorry, we don't know. So yeah, I think that that is a concern, but you know, I mean, I think that if they were going to hire you at this time, when they themselves are considering layoffs of their staff, they must really want to employ you. So they must have that business need. If you are terminated in the future, you do get another grace period of 60 days. So Anonymous asked, my company has announced they will start layoffs. So can I have another employer approve H-1B, but decide to stay with the current one in case I don't get laid off? Yes, you just have to, you know, inform that company and then they have to withdraw that H-1B. Okay, so I think I answered all the questions related to this topic. I want to, for a second, go back a couple of screens and, oops, going the wrong way. So I want to go back to your grace periods. All of you should look at your I-94. So the rule is grace period is 60 days from the date of termination or whatever is left on your I-94. So I did have a client who, you know, heard me speak in early February 2nd with Albert, and I did a prior session of this. And after that, he looked at his I-94 and he realized that he was given an incorrect I-94. And his I-94 was expiring in 1 week. And so we very quickly corrected it with the port of entry CBP, and then we very quickly filed a B1, like all within days. So you do need to do that because you may not have 60 days. I mean, you know, you just need to check your I-94. All right, now let's go down. So I think somebody was asking about this concurrent employment concept. So part-time and concurrent employment is possible on an H-1B. You know, since the economy is what it is, you know, maybe a smaller company that really needs your, you know, your skills, who doesn't have anybody like you, might be safer. I mean, I'm not a recruiter, I'm not in that field, but I'm just thinking. You could have a concurrent employment. So let's say you do get that job offer from AWS, but that startup also wants to hire you. You could do concurrent employment. So take the job with AWS, and once you're back in H-1B status, you have an approved petition, then that startup can do a concurrent employment for a part-time work. Even as little as 10 hours a week, you could get that done. So I have done these for my clients, and you do have to have that first H-1B petition where you are working, and then you find that second job. But could you work at, I had a client several years ago who worked at 3 different startups, 20 hours each, 15 to 20 hours each. You do have to, make the prevailing wage. Even though it's hourly, you still have to be a W-2 employee. Okay, so I do think there are some questions about this topic. Okay, so Anonymous asked about the I-94. That is a good question. What if the I-94 is not updated, as we have not gone out of the country for a while since 2018? You need to look on your H-1B approval notice, that, Form I-797 notice of approval. On the bottom right-hand corner, there should be an I-94 with validity date until. You can also check Customs and Border Protection website, but I'm guessing that's what you're saying. It still says 2018 because you haven't entered an exit. I do understand that. Then your H-1B petition end date, you can rely on that for your I-94. But if you have a concern, you can certainly schedule a consultation with me or another attorney and review. But I think, if you have a valid H-1B petition for another 1 year, 2 years, I think you're fine, probably fine. So somebody is asking about Amazon transferred my H-1B, but they did not transfer my spouse's H-4. They said since H-4 is valid beyond what we are filing for H-1B, so we will just go for the H-1B change employer for you. Is that fine? Yeah, I think that's fine. So does I'm assuming your spouse has an H-4 visa stamp, or maybe if they don't. So yeah, I think that's fine. I agree. Okay, so this next question, there is a slide on this. So right now I am answering questions related to part-time H-1B and concurrent employment. So I know you're asking about changing from H-1B to H-4, B1, etc. And there's, we will discuss that in detail. So any questions related to part-time H-1B and concurrent employment? She has H-1B visa stamp. Good. Okay. And oops, I'm just going to clean this up. Oops. All right. Okay, so no more questions related to this, I take it. I think that, some of my clients who I spoke to in January, late January, I had another big call like this for just Google employees. There were 12,000 who were laid off on January 20th. And so at the end of January, just for that community, Zooglers, ex-Googlers, and there were about 70 people on that call. And so they are still in a notice period, but I am talking to a couple of them, and they are right now. And so they are looking at, startup work. And I think that might make sense. Can you be a co-founder of a startup? Yes, on an H-1B. We're going to talk about that. Okay. I just wanted to let you know, like, if you are hourly, what is your salary requirement? This is just for the Bay Area, Santa Clara, Oakland. Santa Cruz, none of you most likely are level 1. Most of you are level 2 or higher. If you join a startup and you give yourself a title of CTO, that's going to be a level 4 salary, but if you're a software developer, that could be a level 2, maybe. Okay, so somebody does have a question about what if you are a part-time and full-time employee, but your full-time employer laid you off? Then you still have that part-time position. So you're in good shape. You don't have to worry about grace periods. And because you can transfer at any time. Does that make sense? You don't have this situation, basically. So that is exactly what I was actually telling you. The person who asked about Amazon, like if you have that real concern, maybe you take that job with Amazon, you also keep looking and you get you don't change jobs from Amazon. You keep working at Amazon and then you keep looking for another position, which might be part-time. I don't think you need to do 2 full-time jobs. That's a lot. And I don't think USCIS may or may not approve it. I don't know. But I'm not suggesting everyone go out and get 2 jobs. I'm just saying that if you are concerned, then you could do that. That could be a strategy because it saves you if you are terminated. Okay, so somebody's asking, where can we check levels to ensure we are getting paid enough? They should be giving you, when you do an H-1B case, the employer is required to give you a copy of your wage memo, and they are required to give you the labor condition application. So they should be telling you. And for my clients, I tell them, this is your prevailing wage. Now, could they decide that, you should be a level 4, but they're paying you level 2? Yeah, that happens. That definitely happens. So, if you have that concern with your current company or a future company, you can call me, you can talk to me, schedule an appointment. We can do that analysis. But that is a strategy that some companies might use to give you a certain level. Okay. So I know this is, a lot of my clients, I made these slides based on the questions I was receiving from my clients. So yeah, I mean, if you have a green card already filed, a Form I-485, and you have an EAD, then yes, you can work on that EAD. And that green card application that is pending, that's sort of your quasi status, and it's fine. It is a period of authorized stay. So you are fine with your status. Any questions about that? Has anybody been in this situation? Okay. So I see some people are asking questions in the chat. I am looking more at the Q&A. I just opened up the chat. And so I think you asked already, Rajan, about minimum salary requirement for part-time H-1B. Yes, that would be the hourly rate. And there was a slide about that. I can go back to it. This is the wage levels that I pulled up for the Bay Area. It is based not on you could have a PhD, but, 10 years experience, but for whatever reason, you have decided that you're going to take a position that is more mid-level, because that's just what you want to do, or you just need a job right now, right? So salary levels, wage levels, these are called prevailing wages, are determined by calculation is based on the position requirements. So if it's a CTO, that's different than software level 1. Engineering manager is different than software level 2. So it's not so much what do you have, what do you possess, but what is the position required. Okay. And again, this is for a software developer. Maybe you are a QA engineer, maybe you're a computer systems analyst. So those are all different codes. Okay. So this is just software developer. Maybe, and by the way, there is 2 different kinds of software engineers in the Department of Labor's database. So this is just an example. Okay. You need to, if this is an issue for you, a concern, I would recommend you talk to someone and not just assume that you should be making level 3 in San Francisco. Don't assume that. You could depart if you, feel like there might be more opportunities in India, honestly. At this point, I know you don't want to depart. You're rooted here. You have, family or children maybe in school, or you just simply want to find another job and continue your life. I understand that. But let's say nothing is working out. You do have this choice. Your H-1B freezes. So let's say you're 3 years into your H-1B. So if you exit and the remaining 3 years you can recapture. And you can actually add on, if that makes sense. So you don't have to go through the lottery again. So questions about this topic. Okay. So what happens if we depart and the employer withdraws the H-1B? Does the employment still exist and valid? Yes. Your H-1B petition was withdrawn with that company. You have still been counted against the H-1B lottery and the cap once. So pretty much, I did a case 9 years. This person was in India. They were in H-1B status 9 years ago for 1 year. And then they went home, and they were a consultant, and then they said, I'm just going to work from here. And now one of my clients, a mid-sized company wanted to hire them. And so we reactivated that H-1B. It's not an issue. So that was 9 years, So somebody is asking, I will answer this, even though it's something unrelated to this topic, but does one need a second H-1B for a second part-time job? Does an employer or employer need to file any application? Yes, concurrent employment. So what you're describing is concurrent employment. H-1B employment is for one company. So if you want to work for a second company, you need to be sponsored by that second company. And on that H-1B petition application, the company would select concurrent employment. That's an actual term on the form I-129. They would not select change of employer because you are still going to keep that one job. Okay. So somebody is asking, what if we have already used up 6 years, but you have the I-140 pending? If your company isn't withdrawing that I-140, and then you might be able to extend beyond the 6 years. Obviously, you need a job offer, same or similar occupation, et cetera, et cetera. But it's, this is very fact specific, but if it's pending and it doesn't get approved within, the grace period, they withdraw it, then it's gone. You don't have an I-140 anymore. But again, if it's perm-based or, is it a multinational manager based? There's so many different variables. So Dibu is asking if you change to B1 visa and then, and then later exit, can you still come back in H-1B? So I would recommend, if you're going to apply for a B1 visa, to work with an attorney. Maybe you can do it yourself online, but you don't want that B1 to be denied. It's high risk, if it's denied and you stayed that entire period of, 160 days, 180 days, it's only valid for 180 days, the B1 visa, the B1 status change. And let's say later it gets denied, then you have accrued all this unlawful presence, which could hurt your ability to get an H-1B visa in the future. You don't want to accrue more than 6 months of unlawful presence. Let me just tell you, we're going to talk about B1s in a second. There is a slide, but generally, yes, you can come back on an H-1B. That's your question. You change to B1, but then later you depart while it's pending. Can you come back on an H-1B? Yes. You should withdraw that B1 before you depart, because anytime you do a change of status of anything, there's no travel allowed, or the case is abandoned and then denied. So you want to withdraw it. I mean, if it is denied, it's okay, but CBP is going to, question you and harass you upon your next entry. They're going to say, oh, well, we see a B1 was denied. What happened? Tell us what happened. And then now you're coming on an H-1B. Why did you switch to a B1? And you just don't want to deal with that. So you want to withdraw it timely before you depart. Okay, so okay. I understand I mean, 60 days is not enough time. You don't need a reason, like your wife is pregnant. I understand that, but even if she wasn't pregnant, 60 days is not enough time, right? To uproot your life and move. I totally understand that. It's not fair. So somebody else is asking, they have an I-140 approved, but they change employers and the I-140 process is not completed by the current employer. And then you are laid off. Do you lose your I-140? I don't know, maybe. It really depends on if that current, your current employer, do they withdraw that I-140? I would recommend, we look at the documents. Can you premium process that I-140? Can you ask, if you can ask for a receipt and you can premium process it yourself, maybe. But the considerations are USCIS, I'm sorry, your prior company would notify USCIS that your H-1B is being withdrawn. So when the officer looks at that I-140 case 3 months, 6 months from now, or maybe even next month, they're going to see that you're no longer employed by. So I think it is in jeopardy. It's likely in jeopardy, but I think that's more of a one-on-one conversation. So Debu, let's talk about B1s. I know you have more questions about this situation. So let's just go to, do we need to talk about TNs? Somebody who is on a TN visa, raise your hand. Or put it in the chat saying, yes, I'm on a TN. So TNs are for Mexicans and Canadians. I'm just going to wait. Nope. Okay. So let's not even talk about it. O1s. I am going to just mention that O1s also have grace periods. Why, if you're on a TN, if you're on an H-1B currently and you have been terminated, if you think you might be eligible for an O1, maybe this is something to consider. There are no prevailing wages. You can get together with your friends, other laid off workers, start your own company. You're not able to find a job, start your own company. You can't do it on an H-1B unless you have co-founders who are not H-1B visa holders, but others. We're going to talk about that in a second. So you can apply for positions within your field. You can, work for multiple companies on an O1, including your own. So I think if you think you're eligible for an O1, this is something kind of cool. And I do a lot of, O1s for, tech clients. You can do it pretty quickly. I think I wrote 4 months is sufficient time to create a new O1 case, but even if you have 6 weeks left, it might be possible. Okay. Do we need to talk about this? E3s are for Australians, H1B1s are for Singaporeans and Chileans. Somebody, if you are in one of these visas, nope, okay. L1s, I'm sure there are some L1s on this call. There are 29 participants. Somebody want to put their name in the chat if you want to talk about L1s? Okay, moving on. Self-employment. How can you, as an H-1B visa holder, start your own company? So first of all, you need to own less than 50%. It needs to be a real venture and not just something for the sake of the visa. However, maybe this is something, you could do for 1 year, 2 years. And then when you get that job offer from Google or AWS, you can keep your H-1B with your company and still work there for 10 hours or so. And it would be a concurrent employment type situation. I mean, if permitted, of course. Again, you do have to, be paid a prevailing wage. And so, again, don't call yourself the CTO, the CEO. You would have to get together, if you have a startup idea, you've been carrying that idea around for several years, maybe you have a pitch deck, maybe you have a prototype, that is something you can start developing now. I think the ideal case is one where you are an employee, you own maybe 49% or 33%, and the other co-founders, ideally there should be 3, 2 or 3 at least, is the CEO or the lead. Maybe they're the founder, CEO, and that person is the signatory. Okay. So any questions about this? Oh, okay. Do we need to talk about E2s? E2s, notable exceptions are India, China, Russia. So E2s, I am doing some E2s right now for laid off workers who are Canadian, and I think one of them is Mexican. So no questions about E2s. Okay. This is the criteria for an O1 right here. Membership, leading or critical roles, high salary. So somebody put in the chat. Okay. I do see your question and we're going to answer it in a minute. So does anybody have any questions about the O1A or the EB1A self-petition? Nope. All right, let's go down. All right, so this is what individuals, a lot of you are already asking about. So let's say that you, during your grace period, that's the #1 scenario right here. You have filed for an H4 or a B1 change of status, some other F2 maybe, or F1 maybe. So you have done that within your grace period, and then later you have filed the H1B transfer petition. Then there's no issues, basically. You can file again a H1B transfer petition, and then withdraw that H4 or B1 or whatever it is. So in this situation, you have filed a change of status and the transfer all within the 60 days, but the transfer was done after, right? The change of status is pending. Okay, I think it's more confusing if you file that, you're trying to file that H1B new position, new job after the 60 days. I think that within your 60 days, you have filed that change of status. This is that situation where it's up to officer discretion. Do they approve your extension of status? I don't know. I think they might. And I think the fact that you have, previously filed that H4 B1 change of status, that might increase your chances of getting that approved, because it shows to the officer that you have been maintaining your status. So Vid, I think, we're talking about that. You can change to B1, or if you are married, H4. Any questions about this? This situation that on this slide. Okay, so there are some questions. It says, Anonymous is asking, if we get an H-1B sponsor while the B2 is pending, are we compulsorily required to go for consular processing? No. So you just have to withdraw. If you file that B2 change of status, that H-1B extension of status may not be approved, may or may not. You just have to explain it to USCIS when you file that H-1B transfer. You just have to explain it and say, I had filed this, B1, B2 change of status because my 60-day grace was, about to end. And at this time, however, I do have an employment offer, and I would like my petition and my extension of status to be approved. Let's say USCIS decides that the extension isn't approved. Then if you have a valid visa stamp, the H-1B visa stamp in your passport, you don't have to go to the consulate in India or Mexico or anywhere else. You just have to get back in H-1B status. Again, Jamaica, Mexico, you don't have to go to the consulate. So when you say consular processing, in my mind, that means processing of a visa at a consulate. You don't have to do that if you have a valid visa stamp already, even if it's with a different company. Okay. So it says, can I switch to B2 while I'm searching for a job? And once I find the job, I transfer my H-1B. Would I need to leave the country and come back? Or it's change of status of it's illegal? Well, I think I just gave you that exact example, that situation that I just spoke of, I think should answer your question. If you're still uncertain, you need clarity, please, write a follow-up question. So somebody asks, do I need to leave the country if my H-4B1 is approved? No. So first of all, these things are going to take a long time to get approved. They're going to take more than 6 months. So that change of status is going to just be pending forever. If you depart the country, then that change of status application to H-4B1 is considered abandoned, and it will be denied. You need to strategize, if you have an H-4 option, does it make sense to depart and, go to Mumbai or elsewhere, look at the visa processing times, applications, and get an H-4 visa stamp and then re-enter in H-4 status? Does that make more sense to you? If you don't want to leave the country, then do the change of status and then keep looking for that job. And then try to get back in H-1B status. And again, if it's been 6 months, and the H-4 is still pending, your grace period was over 6 months ago, more than likely that extension of status is not getting approved by USCIS because it's been 6 months after your grace period. So again, Mexico, Jamaica. Why I keep mentioning Jamaica? Because Indian passport holders can enter Jamaica without a Jamaican visa. So you just need a little vacation and then you come back. So so somebody is asking about the situation if the B1 change of status is you have applied for it, you have filed it within the 60-day grace. Can you apply for H-1B transfer after the 60 grace? Even if you don't have a H-1B visa stamp currently, you can try, certainly. And again, just ask for that extension of status. USCIS has the discretion. They could decide not to grant it to you. In that case, you would have to go get an H-1B visa at the consulate. You cannot go to Jamaica because you don't have a visa. So an H-1B visa or any other kind of visa stamp allows you to apply to enter the US. It's a travel document, essentially. And so if you don't have it, then there's no way that CBP can let you in that status, okay? So somebody is asking, Anonymous is asking, if an H4 change of status is pending while I file for an H4, can that be an issue? Should the withdrawal happen before I file the H1? So, I mean, you don't have to withdraw it before the H1B is filed, but you should, you know, if you're working with me, then I kind of understand your situation. Or you need to explain to the new company that you filed it, because, you know, I mean, you don't want to just be here for 90 days, 120 days without filing anything. I don't recommend that. If I think that could result in like a future visa stamp, you know, USCIS saying, well, you exceeded your grace period. I mean, if you exceeded for 5 days, that's a little different than staying here for 60 days, 90 days. So I think that more than likely in the question that you're asking, you have an H4 change of status is pending while, and then later you file the H1B. There are a couple of options. The new employer, the company could, when they file it, also include the H4 receipt and say, please withdraw this. You know, the applicant is now asking to be in H1B status. Please withdraw the H4. They could wait for an RFE if that happens, or they could just approve the extension of status. That might happen, you know, but you just need that strategy. And again, if you're concerned about this, and if it's, you know, a smaller company, even a mid-sized company, you can say, I spoke with an attorney, you know, is it okay if she files my H1B? And then I wouldn't charge anything, of course, for the withdrawal or the additional strategy. So you just hold on. I'm going to turn on the lights. It's just gotten dark. Excuse me. Okay. All right. So somebody is asking, related to this, can we work for a Canadian employer as an independent contractor, get consulting payroll in India while we are outside grace period in the US awaiting B2 approval? So I do get this question, these kinds of questions, actually. And so basically, USCIS is unclear. It's a gray area whether you can be in the US as a visitor, because you know you have applied for a B1, B2 change of status, and work for a company outside the US. If that is a multinational company and they have a company in the US, I think that's a clear issue. It's a problem. I don't recommend this at all. But it is a legal gray area because, you know, in this global world of remote work, people do travel into the US, enter as a visitor, and then, you know, maybe on vacation, they check their email, you know, and do some work for 1 or 2 days for their position abroad while they're on vacation and traveling in the US. So is that unauthorized work? I mean, potentially, yes. So what you're asking me is, can you work in the US while your B1, B2 change of status is pending, getting paid in India? I don't recommend it. I mean, you know, maybe you could go to Canada and work for that company. That might be easier. So someone is asking that when you change your status from H1B to B1 or B2, you have to do a biometric. Yes, you normally would generally, but you also want to fly back to India before the biometrics, do you need to withdraw your B1 change of status? Yes, because the rule is that anytime you have a change of status application for anything, whether it's a B2 to H or H to B, whatever it is, H1B to F1, you cannot travel or the case is abandoned. So you should withdraw it. So then you're asking, does that mean that since you withdrew the application, you were out of status while it was in the US? No, because you filed it timely and it was pending. So you're fine. Okay. Somebody is asking, what is the current approval timeline for a B1? I would have to check the website to give you the exact time, but that USCIS web postings on their website are not always accurate, first of all, but it's going to be more than likely, it's going to be more than 6 months. So a B1 visa, I'm going to actually go to the B1 slide. Here we are. So the B1 visa has a validity period of 180 days. So that means that you can only request a B1 for 180 days, B1 or B2, any sort of visitor, temporary visitor. And just like an H1B, it's valid for 3-year periods, and then you have to do an extension. Same thing with the B1. The B1 is valid for a 180-day period. However, if you file it, March 1st, let's say, it's going to be pending longer than 180 days. So you need to calendar and be very careful about this, that you do not stay beyond the 180 days. Because you file it March 1st and 6 months is, what is that? Like October, let's say that in October or November, it gets approved, but you stayed longer than 180 days. And now you're sort of out of status because the approval date will be, let's see, April, May, June, July, August, September. Right? The approval date will be until September 30th, but it's still pending. So you're still here in October. So I don't know if I'm being very clear, but it's going to be approved for basically 180 days. So you need to depart before 180 days, regardless of if it's pending or not. Okay. Or I don't recommend you file multiple B1 extensions while one is pending, which some people do. It's not recommended because if they get denied and you have another one, that next one will be denied. And now you've been in the country legally for a year and you're banned, you have a permanent travel ban from entering the US. So I just think that's risky. So the approval time is more than 6 months. That's what I'll tell you right now. It says my grace period ends March 27th. So you just need to have it filed before March 27th, okay? What is the current approval time for premium H1B? I mean, up to 15 days. I've gotten some approved in a couple of days, but it's pretty, it varies. Oops. So this is the B1 business visitor. You can engage in short-term trainings. If you decide you want to start a company, you could set up operations. You could attend a business conference. If you're in the Bay Area, there are so many business conferences, because in order to increase your chances of success for a B1 to be approved, you need documentation, in my opinion. And so getting documentation of a conference is not so difficult. And by the way, it may not be approved for the whole 180-day period. If you have a conference that you want to attend in April, it might only be approved until April. They said, okay, well, that's your documentation. If you want to pursue a visitor visa, I think if you say, I need more time, I have a house, I'd like to sell it, my children are in school, I have a car, I think that's fine. You want to wrap up your affairs. I think you can file that. I don't think you should file multiple. No. I think that you should leave then within another 60 days. I think filing a B2 visitor for tourism or even a B1 and then later filing an H1B 90 days, 120 days later, 3-4 months later, that extension will most likely not, be approved. I think if it's a B1, maybe there's a higher chance. And then you would have to, again, go to Jamaica or go to India somewhere. So I do see some questions. So Debut, thank you for reposting this question. So you asked, change your visa from H1B to B2, and then you have your baby, you have your newborn. Will you be able to get a US passport for your baby while your B2 status is pending? Yeah, because you just need the birth certificate for your baby. They shouldn't be asking for your legal status. I mean, as far as I'm aware, I'm not like an expert in getting US passports for children on B2 change of status pending cases, but I think so. You need the baby's birth certificate and social security card, and I think that's really it. So someone is asking, while outside grace period and B2 application is approved, can we continue to live and interview in the US, or are we required to exit? So, yeah, I mean, the whole purpose of filing that B2 change of status application is so you can stay here in the US lawfully. So you are not required to exit. You can continue to live here and interview here while the B2 is pending. Again, it can only be approved for 180 days. So even if, 160 days are coming up and it's still pending, you need to depart. You should not stay beyond 180 days. That's very important. Okay. So I think we've covered this slide. Oh, we're going backwards. So do we need to talk about F1s? So these are F1s who have been on OPT working and they were terminated. Okay. Somebody in the chat is asking, is ESTA equal to B1 in this context? So ESTA is a form of entry. It's sort of like a visa waiver. If you are on ESTA right now, you are not eligible to change your status. ESTA is also only valid for 90 days. The B1, if you are on a B1, you can change your status, you can extend your status. So it's not exactly the same. Paulina, I don't know if I answered your question, but basically you cannot change to ESTA. No, that can only be done when you are entering the US, you are given ESTA status. You could change to B1, okay? So Rosa, you have said yes, so you are on an OPT, I'm guessing. Do you have a specific question about OPT? So, I wrote here that you must report to your DSO, that you have been terminated, but you don't have to do it, until your grace period is about to begin. There is a period of unemployment that is considered authorized. You could, find another position and then, get sponsored with a new employer at OPT. Okay. So Rosa, do you have any questions about the F1 OPT before we move on? And there are more questions about B, so we can take those. Okay, so you're putting in the chat. Okay, good. Great. So, I think, Rosa, your DSO would be the person to talk to. So somebody, let me just change the slide and then we will continue talking about these. So you can read this while I answer your questions. You can talk about changing status to F1 or H4. So somebody is asking, can you change your status from B1 to H1 if you enter the US on a B1? Yes, I mean, as long as previously you have been counted against the H-1B cap. So you have an old H-1B petition that you're trying to use. Yes, you can. Somebody is asking, can we change our status from B1, B2 to H1 if we entered US? Okay, so I think that's the same question. So yes. Okay. Somebody is asking H1B to F1 options. Yes, you can do that. If you have to talk to the school, get the I-20 done. I did do it for someone on a B1. They were a nanny and got an F1 quickly. It was approved quickly. So if you go online under USCIS processing times for F1s is very long. But that I-539 application was approved pretty quickly because we had the enrollment date as 30 days. So, that is something to consider, like for maybe a lot of individuals during your grace period, switching to F1 might not be the best option because there is no premium processing. Change of status takes a long time for an F1 and you'll miss your enrollment date, right? If you're trying to begin in a summer program, you may not get an F1 status. So that is the issue there. So maybe you want to consider H1B to B1 to F1, something like that. So somebody's asking, can we file for B2 in the last 3-4 days of H1B grace period? Yes, as long as it's filed within your grace period. Again, I do recommend day 55 taking action. FedEx, maybe you could do this online. USCIS website is not, it's buggy. There are lots of bugs, but yes, I know people do it online. You could do that. You could also work with an attorney to do it. All right, so okay, so somebody else is asking a question about priority dates and I-140. So I am going to answer that because it is related to F1. So you're right. I have an I-140 approved with a priority date in 2017 and your current H-1B is approved till 2025. Can you transfer to F1? Yes. And then back to current H-1B once you get a job? Yes. Even if your change of status is in process. Yes. You can absolutely. Okay. So somebody else is right. I'm on an H1 and my wife is on an H4. Can we change our status to B2 and then wait for next university admission and then change my status to F1? Yes. And then potentially someday H1 and H4 again. Yes. All of that is possible. And the good part is that your H1B freezes, like, let's say you have 3 years left on your H1B. So you would get that back, of course. Okay, so I think I've answered this, group of questions related to B's and H's, etc. So a lot of you might end up, unfortunately, if you don't have a job offer within that grace period and hasn't filed it, you might be looking at a B1 or B2. Just remember to do it very carefully. It looks like a simple form, but if there is a small error, those things do get denied. And then you've been in out of status for so many months. So it is important. So would anybody like to talk about this? Like, let's say you have been, you have an offer, a marital offer, or you are dating somebody who's a US citizen. Okay, so Rajan has a girlfriend. Just kidding. So you can do the I-130 petition and the green card application concurrently if you are married to a US citizen. If you are married to a permanent resident, we have to, or will be married to a permanent resident, we would have to check the visa bulletin, see if it's current for dates of filing for whatever month in which you want to file. And if it is, then you are eligible to file it concurrently. Most of the time it is. So marriage certificates, at least locally, do not take a long time. But you know, that EAD card will take 5 to 7 months minimum. So it's not like you're going to get quick work authorization, but at least while the case is pending, the green card application is pending, that is your status. And you can continue looking for H-1B jobs. Okay. So Rajan is asking, how soon can I start working? So you're talking about the question of, you have a marriage-based green card filed. So again, the EAD will take 5 to 7 months after you do the biometrics. And so biometrics for my cases are pretty fast, 1 month maybe. So if you want to work on an EAD, it's 5 to 7 months minimum. Once you file that marriage-based application, you need to file it in the grace period, once again. Ideally, if you're married to a US citizen, you're actually forgiven if you're out of status. So that's not an issue for you. You could do it later. I do recommend trying to do it in that 60-day grace, however. And then you can continue looking for jobs in H-1B and you can transfer. Okay. So Rajan is asking, continue looking for H-1B jobs beyond your grace period, which ends on March 26th. Yes. Again, do you, I think it becomes a little tricky because if it's outside your grace period, USCIS should consider your adjustment application as an action taken, right, within your grace period. And thus you have been maintaining, you know, some status, obviously. So they should approve their extension of status on an H-1B, but it's up to their discretion again. I don't know if they will approve that H-1B or not. Now, then it becomes even trickier because when you file an adjustment of status to green card, in many cases, you cannot depart the US or the case is considered abandoned. So Rajan, I think you have a tricky situation. Unfortunately, like I would, you know, I mean, if you want to marry this person, you should, you know, maybe wait until the close to end of your grace period. Okay, so you said March 26th, so it's coming up. You have less than a month left. But I think your extension of status for your H-1B should be approved. Okay. Any other questions about marriage? Again, if you have brothers or sisters of adult US citizens, you can start that petition. Oops, excuse me, F4. All right. So national interest waiver might be an option for you as well, depending on your field and, you know, what your future plans are. I do have another seminar just on self-petition, which includes NIW, EB1A, extraordinary ability, and EB5. Okay. EB1A leads to a green card, self-sponsor, no labor certification. So that is the advantage of the self-petition, these 3 that I just mentioned. You don't have to do a perm labor certification ever again. You just go straight to I-140 stage, okay? So Rajan says, well, it's a court marriage. Okay, no murat till mid-May. I understand that, but I think that I think you'll have to do the proper ceremony at a later time, and try to find that murat in 2 weeks' time. You have 3 weeks, really. Do that marriage certificate. You can begin the case with an attorney, me or someone else you're comfortable with, in advance. You can do all the paperwork, and as soon as you have that marriage certificate, you file. But you can do it outside of your grace period. You don't have to, again, do it right now. I mean, if you're risk averse, you could decide to just file the B1 right now. Actually, it would be a B2, and then later get married and then file the green card application. It's really up to you, but I think you should do it now. I think you should do it in March, because it is a court, it's a court wedding. All right. So I think this is my last slide. If anybody has, any further questions. If you go to my website, there is a calendar and you can schedule directly yourself. And I did open up a lot of appointments. So hopefully I can speak to some of you and get to know you and try to help you in this crisis period. Okay. How, I see that there are some more, so Nivdia is asking about investments-based EB5s. Sure. Well, we have 4 minutes left, but I can certainly, I just stopped the screen share. So here's the EB5 visa.
Did you want to stay on longer to answer questions, or do you have a hard stop?
I don't have a hard stop. My hard stop is I have a 4-year-old.
Okay.
If he runs into my office, that's the stop.
Okay.
I am at home. So, so Julia says you asked 2 questions in the QA and it wasn't answered. Okay, Julia, let me look for your questions. And Nivdia is asking about EB5. Did you put it in the Q&A or I'm scrolling through for your name, Julia. If you want to, I don't see your name, Julia, so I'm sorry. I don't know how it got missed. It was related to, okay, do you want to just ask me, repost it? Because I don't see it right now. Okay. So you write, you were outside of the country before you were laid off, and then you went through customs. The CBP put your I-94 expiration date to your passport expiration date, okay, which is earlier. So was your passport expiring in 6 months or less? Is that what happened? Then how can I get that corrected? No, my passport expires next year. So they did likely make a mistake, Julia. I mean, you have to contact the Customs and Border Protection near you. You don't have to, let's say it's JFK, but that was just where you were flying through, to get to North Carolina, then you can get it through North Carolina. You have to contact the port director or the port authority, is there a way to do it online? No, generally not. Every port of entry, basically an airport, Customs and Border Protection at airports, will have a process on I-94 corrections. There is often an email and to get it corrected. Again, different officers at different, CBP officers at different airports have different mindsets and processes. You might be better off, talking to a lawyer about this. And I mean, when does your I-94 expire? Because I'm concerned that it's already expired, right? Okay, good, in 2024. So you were given an I-94 until 2024. So I think you're okay, but you want it until 2025. So yeah, I mean, you can try to get that corrected, but I don't see that as like an urgent need right now. When you file, if you file an H-1B transfer, you should get a new I-94 for 2025 or 26, whatever that extension date is. But you can certainly contact me or somebody if you want to try to get that corrected. Or you can go to the website of Customs and Border Protection, at the major airport near you. Like I know in the Bay Area, it's mostly SFO who does it, not San Jose, not Oakland. So CBP corrections is in SFO. So Nishant is asking, sorry, Nivya did have the question, Nishant, before you did about EB5's investments. So most of you, if you are on an H-1B or an L, or you've been working for a company, then obviously you don't have your own company in which you can invest. You could invest in a regional center, which is a passive investment, and you have your H-1B or other visa status, and you are employed at a company. Then you can invest in a regional center. Regional center is somewhere where investors, professionals, maybe whether they're in the construction field or they basically pool together individual investments from individuals like you, from US citizens, from others. And the minimum investment amount varies based on whether it's a very rural area, and they call it a TEA, targeted employment area, or an area of high unemployment. And, the properties or the types of investment projects are just, large scale residential development, whether it's commercial like apartment complexes, or it is a commercial project of a mall or something happening, and they're looking for investment. Oftentimes the ROI, the return on your investment, is pretty good. 10, 12, 15, 20%. Sometimes it's better than the stock market right now. So it's not a bad investment either, but you have to come up, you have to have $1 million. That's all. So I'm just seeing, are there questions about this particular topic? So someone just asked, what is the minimum investment required for EB5? So I think I just covered that. It would be 1 million. Again, for a regional center. I mean, if you can get an O1 or an E2, but E2 obviously as an Indian, you're not eligible. You could start your own company. But generally speaking, it's either 800K or 1 million. Okay. So somebody's asking, how long did the I-94 correction take at SFO port of entry? Last year I did, a couple of corrections for my clients or new clients, and generally a week. But if it's like an urgent issue, and if you're really nice, and you call them and email them, maybe they'll do it sooner. So any more questions about EB5s? I'd be happy to, there are a couple of more questions here that I'd be happy to answer. Somebody's asking about if they file a change of status from H-1B to F1, and the university starts in August, September 2023, and your case is still pending. What happens then? Well, you're not considered out of status because it's still pending, but you haven't enrolled. So that's sort of a situation you don't want. You want to try to get enrolled. In my experience, when I've done this with F1s and you show that you have, enrolled and you have been issued the I-20 and it's starting in August, USCIS should approve that faster. I mean, I just filed one in November and it was a January start date and it was approved in December. It was really surprising even for me that it was approved so quickly. But somebody's asking about compelling circumstances. I know there have been a lot written about this, and I mean, I don't think that it's an impossible situation, but it's very circumstantial. H-1B EADs for 1 year under compelling circumstances. So the example that USCIS, gave in a conference that I attended last year was a hospital scientist for some reason has an H-1B that has expired or is expiring. The green card hasn't been filed yet. And so the scientist is working on cancer research. And if the H-1B employee loses work status, then the grant cannot be fulfilled. These are the compelling circumstances. And if you think about it, the compelling circumstances of the company and the national interest, cancer research stops, grant is lost. It's not so much of the scientist. So I think there are other situations, but I think the compelling circumstances is going to be hard. I think just arguing that you have a large family and you are the breadwinner, I don't think that is going to work. They're going to just say, well, just depart and go home. I think they're just going to say that. But be happy to discuss it on a case-by-case basis. So Fernanda is asking, you got paid for one pay period and then you were laid off. Is that going to be a problem? I don't think so. I think you just need one paycheck and you need to look at that date. You should, obviously have a grace period, and that grace period should begin on the last paycheck period, not the severance, but the full pay. Okay. I think I have answered most of your questions, or if not all of them. Are there any new questions? Nope. Okay. Well, I think it's been a pleasure. And again, I'm deeply sorry for what's happened, but I hope to be able to help you as best as I can. Please do reach out, and on my website directly, there is a calendar, or you can also email me if you can't find the calendar or something. Okay. Well, thank you so much.
All right. Well, thank you, Ashima. We appreciate you coming on to do this twice for us. It is a very unstable and crazy time for a lot of folks. And so we will be putting this video on our YouTube channel, and you can also join our Facebook group, and I'll include both of these in our follow-up. Thank you everyone again, and we hope you found value in this video, and we look forward to seeing you again soon. Thanks everybody, and happy Tuesday night.
Bye.